Hey guys, Madonna Hermes here with Hermes Law. So what is a typical divorce process? How does it go? What's involved? What do we do? Where do we start, right? So a typical divorce in Michigan requires at a minimum that you meet the jurisdictional requirements. Now in Michigan, that's a requirement that you live in Michigan for 180 days, the 180 days prior to filing, and then you file in the county in which you've resided for the preceding 10 days. Now, what documents are required to start the divorce process? Well, you'll need a summons and you'll need a complaint for divorce. Another really important document to file is a mutual restraining order or a status quo order. And it's typically used in financial situations to basically bar both parties from making any financial decisions that are not basically are inconsistent with the status quo. So for example, you'll file it so that you prevent your spouse from maybe dissipating assets or concealing assets or hiding assets. You would file it to prevent somebody from maybe going on a shopping spree or withdrawing, the $10,000 that you have in your bank account. Now, usually it's mutual, so it means that neither party can basically do anything that's outside the status quo. Once you have those documents ready, you'll need to serve your spouse. So you'll need the summons, the complaint, and if you have a status quo order or a mutual restraining order, you'll have to serve them with that as well. You will serve them with the documents, usually through a process server or through the sheriff's department, and they will have 21 days to respond formally to the complaint for divorce. And they'll do that by sending in their answer to the court. If your spouse chooses not to file a response or not to appear, you then will ask for what's called a default. And if you file a default, you're basically telling the court, hey court, I've tried to get a hold of them, they're notified, here they've been served, and they don't want anything to do with the divorce. And that ensures that even if your spouse is unwilling to participate in the divorce, it doesn't stop you from getting a divorce. Because we've all heard, maybe not all of us, but I'm sure, you've watched TV and you've heard someone on TV say, well, I'm not signing the papers. There's no such thing as not signing the papers in Michigan. It only takes one party to file for divorce, and when that other side is served, then the divorce goes with or without that defendant, whether they want to participate or not. So if they don't want to participate, then what we would do is file a default and ask the court to continue the divorce proceedings without that spouse because he or she does not want to participate and we can't be held back because of them. Now that you have your spouse served and hopefully they've responded, now you'll begin the process of negotiating your divorce. Now, if you've got an attorney and your spouse has an attorney, well, then the attorneys will hopefully be talking to try to negotiate. And then meanwhile, you and your spouse could also be discussing a possible settlement. That's something that you'll want to speak to your attorney about, whether to reach out to your spouse or not. In certain circumstances, I do recommend that parties talk and try to see what issues they can resolve. And then in others, I recommend they don't talk at all. So it really depends on your specific circumstance and what's going on in your case. Now, how do you actually go about negotiating your case? Well, hopefully you and your spouse are open and transparent with one another, and hopefully your attorneys are able to work well with each other. So that way, both parties can get on the same page and look at the assets, look at the liabilities, and try to figure out what is fair, what is equitable, how do we split this stuff up, and where it's balanced on both sides. And it's basically just a give and take. So, one party might say, hey, this is really, really important to me. I really want this. And the other party might say, okay, it's not that important. You can have that. And hopefully this just goes back and forth where both sides are open with one another and really try to do what's best, considering the whole estate and everything that's involved. So let's say you're struggling to resolve all issues in your case, or let's say you've resolved the financial aspects, but not the parenting time, the child custody part. So what do you do then? Well, when you've resolved some issues, that's great, but you have to resolve all of your issues to be able to actually file a judgment to be done in your case. So what you would do at that point is probably ask the front of the court to get involved and do an interview and investigation. Well, the friend of the court is a body of the court that helps deal with issues involving child custody, parenting time, child support, enforcement, alimony, spousal support, that sort of thing. Well, you and your spouse will sit in the office of the investigator, usually together, and the investigator will ask questions of both you and your spouse as it relates to the child. And they're just trying to get to basically what is in the best interest of the child. Hopefully that report will help both sides kind of come to common ground, and hopefully that resolves the matter. But let's say it doesn't. Well, at that point then, the proper thing to do would be to seek out mediation. Mediation is where a neutral third party is asked to sit in and listen to the facts and make a recommendation to both sides as to how he or she thinks the case should get resolved. A lot of times they'll go back and forth between the parties to try to get to that sweet spot where both are happy. Now, the mediator is not going to issue an order. It's not that the parties have to agree with what the mediator recommends. He or she will just issue a recommendation and tell you what you ought to do, but it basically ends there. If you don't like his or her recommendation, then you don't take it and then you move on to the next step. So what if mediation fails? At that point, then you continue negotiating, but you will then have the opportunity to potentially go to arbitration or to go to trial. Now, all cases, if they're not resolved, end in either arbitration or trial. Arbitration is basically a substitute for trial. It's still going to be a final and binding issue that's decided, but instead of the trial court making that decision, you actually select your arbitrator, and the arbitrator will listen to the facts and the evidence and everything, and then he or she will issue an order that you are bound by, just as if the trial court judge had issued that order. If you decide not to use an arbitrator and decide to go to trial, then the judge would sit in determination of the facts and evidence and will then issue an order. So now you're done. Whether you've negotiated your own settlement or you've gotten an order from an arbitrator or a judge. Now what? A judgment of divorce is the document that lays out the entire understanding as to who gets what and what you're doing for child support, child custody, parenting time, alimony, yada, yada, yada. It basically lays out the whole understanding and agreement in a document that's then signed by both parties, signed by their attorneys, and then filed in court for the judge's signature. So once you file that judgment of divorce with the court, the judge will sign it and you will be divorced as of the date that the judge signs your judgment of divorce. All right, guys, that's it. So now you know the basics of divorce law. So I would love to know what your biggest takeaway was. So please make sure you comment below. Ask me whatever questions you may have, like the video, and of course subscribe because I will be sharing videos with you weekly with really important content to help you empower yourself. If you have any further questions about your particular legal matter and want to seek a consultation, please don't hesitate to call me. My number is 248-825-8042, and you could also reach me at www.hermeslaw.com. All right, thanks for watching.